Thank you for the introduction, Steve. Many of you know me personally, but perhaps you don't quite know the span of things that our organisation does actively breed and bring to market. So not only the crops that are really important for all of us in this room, but we also have a foot in the agricultural camp as well. So we breed things like potatoes, hops, and quite a few seed-based products as well. So I'd like to think that we bring quite a well-rounded view on how things like minimum distance and the EBV concept really do play out in the real world of breeders. Coming from a very small country at the bottom of the world, we're highly export-orientated around all of the crops that we breed for. So it's really important for us to not only be bringing great innovation in those varieties to market, but they bring real value to everybody in that value chain that we speak about in the businesses that all of us represent. People who grow, either at the nursery level, the farmer level, people who invest in the supply chain, people who are the buyers for the consumers who will ultimately, in the case of most of our products, enjoy those amenity benefits or genuinely consume our products as food. And all of the functional business entities that then contribute to that, the banks that bank the revenue, the freighting company that freights those things. So I think we can all feel very proud in our businesses that the innovation from our breeding actually creates huge employment, as well as feeding people and giving them value for enjoyment reasons. And that's where our concern as a plant breeding organisation comes to pass. And I really welcome the points that Peter and Francesco have already touched on in the earlier session, that hearing the viewpoint about the business effect of some of the legal and technical approaches in our IP system is a welcome conversation for them. And the essential question that I felt was important for this session on minimum distance is, why would our specialised IP system allow products that are essentially confusingly similar? And that seems really contrary to the other IP systems that many of us work in to protect our innovations. We had some great examples in the Academy session that Thomas led around the updates on EU trademark law, showing us slides of trademarks that had been refused recently because they were confusingly similar. And many of us who sat in that audience went, well, actually, those things were quite different to me, or, oh yeah, I can see why that was confusing, because that's just a copy with a very small change. And so I think this concept of minimum distance that we've discussed a lot in our organisation and that we wanted to elucidate a bit in this panel discussion today is a really important one. And it doesn't matter whether the variety that we're looking at, that new candidate, has one parent, in the case of a mutant, an EDV, or is the result of a genuine two-parent situation with a great degree of pedigree behind that. And in a market sense, why are we concerned about it? Well, we think that our customers and the people who eventually get to use the products of these innovations in plant breeding are getting really confused. And they may be picking up on Me Too varieties or things that have had a bit of a free ride to get to market that really aren't going to reward the breeder who brings genuine innovation with benefits, because your variety will have to stand in the market on its own merits. And maybe then that breeder is distanced from the value and the reward of bringing that innovation forward. And I think Mike has already made the point really well that all of us who work in that world, then we look in our businesses and go, where and how can I justify this investment? How, when it takes me many years to bring genuine innovation to the market, can I continue to be a plant breeder? What is it going to change about my business? And I think the real fear that if we change our businesses substantially to come more rapidly to market, perhaps with a lower level of change or improvement, is that actually we're going to have a very negative effect for society. We're ultimately going to dilute down or take away the opportunity to really focus on bringing that genuine innovation forward, to bring the real problem solving or the great advance that plant breeding can do. And that is a very genuinely held viewpoint.
Francesco?
So this is really the challenge of our work in granting, because I have to think in terms of what am I granting to an applicant in terms of exclusive IP right when I'm taking a decision. It's a challenge, it's a difficult job of the granting authority, of the CPVO. I said before that I wanted to share with you a case we discussed last week. It is exactly the same setting of discussion. The difference is that we were only 5 people and here we are hundreds. And we had legal point of view and technical point of view, and when it is in that setting, I feel a little bit alone because I'm the only legal, and then I have all the technical experts that bring in the biologist point of view, blah, blah, okay? So, I took some note of the minutes of that meeting without disclosing any confidential information, of course. So to make it short, we got a positive US report, which means that technical examination was done according to the rules, and the expert from the examination office issued a positive US report, and it was a takeover procedure. But this doesn't change the setting if it is ordered by the CPVO, it doesn't matter. So what we got from the notes, the expert identified 2 visually observed characteristics, and the note was identical between the candidate variety and the reference variety. And in order to make the difference, in bracket, the examiner wrote slight or lighter. So there was a nuance, no? It was green color, for example, and then he wrote lighter for one variety. And another characteristic was diameter, also visually observed. So I got the question from the technical colleagues, shall we grant the title, yes or no? Well, I said, on the basis of this information, despite the fact that the US is positive, I don't want to grant the title. I need more evidence. And then the reply of the technical people, yes, but this is visually observed. We don't have evidence. It's just notes taken by the expert in the fields. We don't have measurements. Okay, I said, what do you have? I have photos. Yes, but the photos are not of good quality. We don't see the differences that the expert has seen in the field. I said, sorry, I mean, I cannot follow this kind of line. I cannot just blindly follow the expert opinion of the examination office because I need evidence to take a decision, okay? So this is even more true following recent case law of the Court of Justice in the fruit field. We had this Breborn 78 case in February. So now I think when these complex cases reach the judiciary, the picture becomes more complicated. It complicates even more. But the good point is that we get more guidance from the court. So you may tell me that in that situation we should immediately refuse the title and reject. And I know that this is a position of CIOPORA, which is made public in your official documents in the website. However, on that point, I have to say, it's not so easy. It's not so easy. Because our finding act obliged the CPVO to make investigation on our own motion on issues that relate to the technical examination. And this has been pointed out by the court. So if I have to refuse, I have to get evidence and good, solid background information to take a sound decision. I cannot just say, okay, they cannot provide me with evidence, so I refuse, and that's it. The reason is because we have to apply good administration and we have to look into these issues carefully, and because the technical examination is based on rules, the rules are the technical protocols and instructions given by the office. So at the end, to make it short, I said, on this basis, I'm not ready to grant the title. I don't have enough evidence, despite the fact that the expert is a professional and belongs to an entrusted examination office, so we are covered by the entrustment requirements, by the quality insurance, etc. But I have to see more evidence in the file. And here we come to the borderline and the limit of how it works, because how to document it properly. For visually observed characteristics, I hear and I learn that it is only visually observed. You just take notes on a book note and you don't have measurements. So it's difficult to keep track of this work. So eventually we have also to adjust our practice with the examination offices to see how we can make it work better for the purpose of documenting better what we have. Because traditionally it was always more, okay, it's the expert has said it, the expert has seen it, I trust it, that's it. It's not so easy, and this is becoming more complicated as I see it from the complex cases that are raised with the judiciary. And at the end of the day, when we arrive before a judge, the judge needs documentation and the judge needs something objective. We see it. And there is where the technical and the legal people, sometimes we don't understand each other. Because for you guys, people from the technical field, it's obvious. But it has to be transposed in something which is clear and which is reliable. And we have to be able to make it clear. And they're very difficult because sometimes the technical protocols may be not an ideal tool that solve all the possible situations, like in this case. Identical note, but in one case lighter, okay. It's also difficult to define greens, lighter, darker, is very difficult. On the other side, I have been visiting testing station over these years a lot, and also companies. I can say from my experience, when I see it's not like when you just read the papers. When you see it, you see, oh yes, you're right, it's different. But then how to translate into numbers, notes, on paper. That's very, very challenging, very difficult. And that's, and I conclude, brings us into another never-ending discussion also in the office. What prevails, the paper or the material? The description or the material? At the beginning, when I started in the CPVO, I was thinking, oh, but it's the paper, because you have an official variety description, it's an IP right, you have to stick to that, and the judge will stick to that. But over the years, I started thinking this is not so clear-cut, black and white, because we are dealing with the living material at the end of the day. It's not like a patent where you have a piece of technology and then you have a clear claims, a description, a patent document is drafted in a different way. So all in all, big challenges for us when we deal with these cases.
Yeah, thank you. And yes, this is another very important issue in terms of what the protection of the variety has. And I think it's important maybe to differentiate between two aspects of minimum distance, if I understand the areas that the CIOPORA are looking at. One is what is really the difference for a characteristic that should qualify as being clearly distinguishable. And I think as Francesco has elaborated, there are some certainly grey areas there as to what is clearly distinguishable. And valid to look at those, and the extent to which you'll keep going until you find the difference. There are important issues there. The other aspect, which I think is fundamentally different, it relates to a point that Wendy was making about which characteristics you accept for deciding whether a variety is clearly distinguishable. Because Wendy, you mentioned the fact that in patents, for example, there you have to look at the usefulness, not just innovators, but does this confer on usefulness, does this confer on value? And here I have to go back, it's Groundhog Day, I have to go back to the foundation of the UPOV Convention, because there were certain principles that lie behind the UPOV Convention. And one was, first of all, it was agreed that we needed to be a specific system for plant breeding. One of the elements was that there should be a breeder's exemption. One of the other conscious decisions that I think is there is that in the patent system, you do have this requirement for usefulness, but in the UPOV system, that was never there. It was a clear decision not to say, okay, you have to be clearly distinguishable for a commercially or a useful characteristic. That was not there. And that was a very important decision because it's a fundamentally different decision to make about whether a variety is different or whether it is different for a particular valuable characteristic. And if we're to go down the route of saying, well, we're going to start selecting only characteristics that have commercial value, that would fundamentally change the nature of the UPOV system. I think that's very clear. And that is, and it's very difficult to look at the consequence of that, because as you probably know, there are in the agricultural sector, for example, if you want to release a variety, you have not just to determine that it's distinctly important stable. In many countries, you have to establish that it has value for cultivation and use. So this is the concept beyond the US and plant breeders' rights. And that is a very difficult challenge. And any of you that have been involved in discussions on VCU, and I'm one of them, will understand how difficult to make these kind of judgments are, because it's no longer objective. It's related to the environment you're in, the country. How do you determine what a value is on a potato and what's a valuable characteristic? It's becomes subjective to some extent, and it's determined very much by the circumstances. This has implication for harmonization throughout UPOV, because if it doesn't have commercial value in one country, okay, do you refuse the right in that country because it doesn't have value? There are a whole host of issues that come into play. So it's really a very different set of considerations, fundamentally different set of considerations to looking at, well, we look at the characteristics that we have and what is the difference that we need to ensure, to be sure that there is a clear difference. So two very different sets of considerations depending on which aspect you're looking at on minimum distance. So I think we're aware. There have been a number of discussions in UPOV on this. I think they're still ongoing, and I think we're aware that there's some work being done, and in UPOV we will follow this. But yes, some of these aspects go really fundamentally to the heart of the UPOV system. Thank you.
Thank you, all three panelists. Now we will follow the same format, have a little discussion among the panelists, and then open it up for questions from the audience. So I'm just trying to put your very interesting comments, Peter, about usefulness in the context of CIOPORA's view of minimum distance. We are, in our positions, we make the distinction between different characteristics, which are easy to find, and distinctive characteristics, which, I mean, you're already taking a giant leap into the subjective and because different are, they're fairly objectively verifiable. If you have good data, if you have good field observations and good paper backup and good whatever you need, good measurements, not just a visual observation. So differences are fairly, biological differences are fairly easy to find. But when you're looking for distinctness, you're bringing some subjectivity into it. But is that kind of, our view of distinctness, does that come into the concept of usefulness? I would, on the level I would see it as different. We would not ask the CPVO to determine how useful this new red caliber koa is and we would just ask you to determine how distinct it is. Or maybe it's a question for Francesco more. Or maybe it's not even a question.
And I'd like to make a statement.
Okay, and then Wendy has a comment as well. But I'm just saying, the idea of usefulness is not one we discuss. But the idea of distinctiveness is one that we attach our view of minimum distance to.
Okay, it might be good just to clarify to make sure I understand what you mean by distinctiveness, because does this mean distinctiveness in terms of the marketplace, as opposed to just purely on a technical basis?
We would never ask you to determine whether or not this is distinctive from a marketing standpoint, but in essential characteristics, in fundamental commercial characteristics, or even if, yeah.
But that's the point, that you're saying we're not this shouldn't be used unless it's commercially important as a characteristic. And I think even that creates a huge additional challenge, because already to determine what are technically valid characteristics that are going to give consistent results is one thing. But then to try and get all the UPOV members around the table and say, okay, now we're going to have a discussion about which of those characteristics have commercial merit and which don't. Now, who's going to, I don't think you should be asking DUS experts about that. So who is actually going to decide on what has commercial merit or not? But this is why I say it's fundamentally different way of doing things, and you have to start from scratch, because you really shouldn't ask a DUS examiner about whether something has commercial value or not. They're not the right people. So who is going to determine that in UPOV? Because it has to be, these UPOV test guidelines have to be agreed at the UPOV level. So who's going to go through and say, well, there's a bunch of characteristics, and now we're going to decide which of these have commercial validity, because if they don't, we're not going to consider them. And the problem there, I can foresee all sorts of problems, but for example, if a country says, yeah, but that's not interesting as a characteristic in my environment, so no, you can't have that one. But another country says, yeah, but that's critical, that's a disease resistance for us, that's fundamentally important. And we see this the whole time in other sets, so we can foresee all the issues that are going to arise from that. So I would say it takes a whole different dimension to trying to determine whether something is technically distinguishable or whether it has commercial differences. It's really not an easy step to take. It's really a giant leap to get the whole of UPOV on board with agreeing what this concept.
I think I really welcomed listening to both Francesco and Peter, your viewpoints, and there are some comments more than anything that I would add to that discussion. Francesco, I think sorry, is that better? Yeah. I think, Francesco, you illustrated very well the reality that is occurring because of the marrying of the technical and the legal perspectives. And whether it is intended or not, but that is actually narrowing and distilling down to some very, very fine points of detail. It probably inadvertently is causing a search for very small differences to result in not only difference between candidates and pre-existing varieties, but that distinctness measure that the UPOV system requires. On top of that, Peter, I would say to you that perhaps if we could take ourselves back to those founding times for UPOV, it never anticipated the success that it's actually had. You know, those great motivations of encouraging breeders to really think about benefiting society. But we've moved on a lot of decades now, and a benefit to society today is probably measured quite differently to how it was at the physical times when those first conventions were brought together. And I get that it's a great challenge to bring many and diverse states together in a good, objective and constructive outcome. But why would we shy away from that? Because not only do we want the UPOV system to be really effective and contemporary today, but actually somewhat future-proofed. You know, we really want it to be the system of choice for innovation in plant breeders for the coming years. So we should really take that challenge on. And I think you've got a great willingness through organisations like CIOPORA, many of the individual members of an organisation like this, the ISF group, Planter, AIPH, you know, many of those consultative groups, they would bring forward people that they said have objectivity, integrity, and a great will to help make some of these technical challenges actually solvable. And it will probably be a balance between genuine morphological character, a flavour of some kind of commercial value or impact that actually then colours what these measurements or the solutions can be. But I think you could have quite a willing cohort of people who would bring that intellectual knowledge into play for you to come to the solutions that might help your member states then have a really healthy debate. Not cause them to have to do that work, but to have the constructive arguments to then think among themselves what could the set and the result be. But the ultimate aim would be to space out, not narrow down, the distance between any new candidate and those that have gone before.
In this connection, I would underline the importance of a unitary, let's say, regional system. What is one of the main advantage and benefit, for example, the EU regional system? It's that we can push convergence of practice through harmonization. We don't have to forget where we started from. Before the creation of the EU PVP system, there were national systems. And the examination office that today work for us, many of those offices were already doing their own stuff, their own work on their own. So we really try to get everybody around the table to share. And that's also the reason why we almost cover all the cases for which we need an examination through CPVO technical protocols. The technical protocols have been defined by the court as akin to legal rules, legal procedural rules. It means that if you have a protocol that has been approved, it must be applied. And all the examination offices doing examination on the basis of those protocols should follow this rule. So sometimes I see divergence of practice between one office and another office, and we should try to avoid that, because then it becomes incomprehensible for a judge to say why in this case is judged this way, and in another case which is similar is the opposite. That's not coherent. We have to be able to reach a coherence, and so convergence of practices and best practices on the basis of adopted rules is important. For me, it's essential. It's one of the challenge of the process. And of course, technical protocols are living documents, living tools. I mean, there is a constant need for revision. So all the experts and also representative of the breeder organization participate in these debates to fine-tune what is important characteristic. Reading back in my Finding Act, the basic regulation, sometimes when you read again the law, you find new things you had not known before. The regulation says that the characteristics must be important. It's in the preamble of the basic regulation. But then they say that importance does not mean necessarily that it must be economic important. It's not linked as an equation important, therefore economic importance is not like that.
Yeah, if I could come back, and Wendy, I agree absolutely that just because we are where we are doesn't mean that we shouldn't look forward. And you mentioned the challenge, and maybe what I should perhaps elaborate on is where I see the challenge. Because, as I say, if we were to look at assessing which characteristics should be included, not on a technical basis, but from a broader perspective, and I think you will agree that's not the role of a DOS expert. They can't do that. That would have to be the breeder's perspective. So the challenge would be, how would breeders come together to on all the crops that they need to be able to do that? Because at the moment, CIOPORA has a role to play in the involvement and development of test guidelines, but this is a rather observational role. Here it would be a very, very different role, because you would be determined, you would have to be responsible for saying, okay, well, these are the characteristics that we all agree as breeders. So how would that work in CIOPORA? How would you come together for all these species that have to go, all the UPOV test guidelines, there are 100, and how about the other species that are not covered like that? How do you envisage that working? Because I think it would be a challenge at least as much for the breeders to come together and have a view on that. I'd be really interested to hear that.
I don't have the perfect solution, but I can say that already we organise ourselves very well in this organisation to make a pretty positive contribution on the technical guidelines. So we appoint among ourselves crop leaders, people with a good depth of technical and broad market knowledge of those crops. And we have a very consultative approach. For those people who are acting as crop leaders in this room, we know there's a bit of a carrot and a stick kind of involved in that quite often, or maybe it's cajoling and persuading. Please contribute your time, please contribute your knowledge and give me some expertise here. Maybe herding cats, a better expression, but there is a willingness to contribute that knowledge. So maybe that's only a precursor system, but I think it could be achieved.
Yeah, I understand the way it works, but it's really important to understand, I think, that this is not going to be just commenting on other proposals, but these are extremely commercially sensitive decisions. And when you're commenting on the UPOV test guideline, which is technical, the issue is not quite the same as where you will be making decisions, or you will be making guidance which characteristics to include and which not, which will have business impacts for people. So I think it's going to be a very quantum difference from the role that CIOPORA has at the moment. And I was just wondering on the extent of reflection that has taken place about how that would really work in practice, because I don't think it's at all the same as the role that CIOPORA has at the moment in our working parties on commenting on test guidelines drafted on a purely technical basis. I think it would be wrong to assume that it's analogous to that. I think it's a very different role, fundamentally much more important role. So I was just interested as to what extent that had been reflected and how, all those issues, because they are really sensitive issues, would be handled to make sure that the whole industry is together.
Well, to that exact point, I think, no, we hadn't had a depth of reflection about exactly how to do those things. And with integrity, that could be relied on. What I was wanting to illustrate is that we have, even if it's simplistic and less than would be required in this circumstance, we have a willingness in our model that we know we can organise ourselves. Whether that would need to be elaborated in a different way. But I think if we knew we had a genuine opportunity to go to that next level, to really come forward and among ourselves do the reflection and the work to think about how could that be accomplished, what does success look like, it's the kind of project that our organisation would take on. Taking on that level of effort when you think maybe it's a little bit of a lost cause and we may never get heard on this, is not nearly so exciting.
Okay, thank you, panelists. We will now open, although it's officially we should be on coffee break, we're here in the middle of an interesting discussion and coffee can wait.
Mark Lerner, Project Administration International. You also have to look at the practical side. The breeders investing money in developing new varieties and want to explore it, want to earn money on it. The possibility for that, or the basis for that, is actually plant breeders' right. But without the correct enforcement, you don't have a right. And the enforcement comes back to the US testing. Because Francesco has been talking about, yeah, there's a lighter color and there's a little difference, but you can see it, and based on these kind of differences, small difference, you cannot release or grant a type. That's a technical point, it's a technical observation based on the US testing on one location. You have to take into account that the practical side of it for a breeder to enforce his right that the material, the finished products, will come from several different locations, different climatic conditions, different cultural treatments and so on, but it comes all together in the market. To be able to do the enforcement of your right, the minimum distance has to be sufficient, it has to be clearly distinctive, it has to be large enough for each other, otherwise the enforcement is going to be a very difficult task and very difficult to identify the varieties when they are in the marketplace. So that's also one of the reasons why we are, at CIOPORA, are aiming for sufficient and clearly distinctness in the observations of the candidate varieties before you go to grant it. So that's one of the questions, one of the issues which is very important for the CPVO and the US stations and the examiners to keep that in mind. So it's not just, yes, this is a little lighter color, which is sufficient to grant it, but you really need a larger distance between both candidate variety and the already existing varieties.
Were you looking for Francesco or Peter to respond, Martin? Or
yep.
Yes, okay. So is there, Martin was putting out?
Well, I listen and I acknowledge, and this is driving our discussion on internally in the CPVO when we face these kind of cases. So yes, I understand, and I always think in that spirit when we have cases like the one I have presented you. But again, I have to say that sometimes the point of view of the technical people is different. They tend to look into the technicality, and that if from a technical viewpoint it is for their eyes clearly distinct, then it's a matter of how they make it coherent in a paper, which is not always possible through the technical protocols rules. But again, in this case, who takes the decision? Is the granting authority, so it's the CPVO in this case. We have to judge if it is sufficient basis to grant or to refuse an IP right. And we have broad discretionality in this decision-making process. So we have to be attentive and careful in analyzing the result of the US testing.
Maybe, well, it's clearly a very complicated situation. Could it be a solution in a kind of co-ownership? Let's take the example of Misha saying, yeah, we add something to the variety. Yeah, we do that in good cooperation with the one that has the original variety. Couldn't the co-ownership that is proposed in cases where it is difficult be a solution to take a lot of the friction out of the system? Could that be built in? So you approach it from a different direction than trying to do it on a technical way, much more on the kind of co-ownership. I mean, one of the benefits could be that if it's a new PBR, it would have an extension basically of the original validity of the protection. So there could be a value in for the originator, and there could be a value in for the one that adds to it. It's just a thought.
So you're saying you could solve a minimum distance issue with the EDV solution that the CIOPORA foresees?
Before going to all the
right. So, if everybody heard, Michael was proposing that there might be a business solution here that could solve the issue where the breeder of the new variety, the breeder and the breeder of the original variety have a business decision about royalty sharing and solve the problem that way rather than worry about how the CPVO is going to solve the problem or the courts are going to solve the problem. That's almost more of a question for breeders than for authorities. Any comments?
I'm Peter Oldman, I work for an IP agent in South Africa, and it's really great to hear that the point of view that we need to encourage breeding, because what I read in some of the explanatory notes and what I've been hearing again today is the exact opposite. My good colleague in front of me here has spent a lifetime breeding. I can guarantee him as a practitioner in commercializing varieties that once he's introduced his first new big variety, within 10 years there will be a mutant. Under the current explanatory notes, this mutant will either have a higher color, or it will flower at a different time, or it will harvest at a different time, in which case it is a direct competitor and he doesn't even have to talk to my good colleague in front of me. So I would question whether the benefit to society needs to be so fast that the initial variety breeder does not get his return. So that is the comment I'll have there. Regarding the determination of EED, if there's not clarity, even within the CPVO office, of whether the thing is EED or not, then that surely indicates there's a problem with the regulations. We need to be able to just look at the regulations and see what it is, and amongst ourselves come up with a solution as is being proposed there. It doesn't really need to go to court every time for a solution. I think that's just not a viable proposition. And then I really would like to take issue with the fact that mutant discoverers can get exactly the same reward as breeders. A breeder will invest a lifetime, whereas a mutant discoverer plants a tree and within 5 years he's found a mutation. And it's just part of his farming operation. And with regards to the colour issues and whatnot, is it not time to introduce chromometers into the DUS testing? And then even better, to do online evaluation so that we can see the results as they happen and we can address them immediately rather than going through a 2 or 3 year process, and then only we can lodge our objection. We can go to the test site, go with the DUS test and say, listen, what are you seeing here? Is this not a result of poor fertilization or the way the tree has been pruned or whatever?
So why don't we take the last part of Peter was covering a lot of ground? Okay.
Really, if I could come back on that, I would say we in UPOV are totally committed to ensuring that you have incentives to breed. And if the breeder of initial variety is not getting a return on their investment, there is a problem for UPOV, there's a problem for society, and certainly for your problem. And that's why this seminar in October is so important. And we really need to hear your voices. So I think this is the problem that we've had until now. We've had a lot of discussions about legal aspects. What does that really mean? We need to focus on other consequences so that we can understand and get the interpretation right for the consequences of what the convention is about. now maybe just if I could come back on Martin's point, because actually it's very interesting, and the way you phrase it. My whole issue with minimum distance is trying to understand how this is going to work, because it's a challenge. It's not to be defensive, but to say, you know, how we understand the issue about how is this actually going to work in practice? How are we going to identify this new way of doing things? We're going to forget, you know, technical objectivity is the other thing. We have some other factors. I think, Martin, what you put into my mind as well, maybe there is an issue about characteristics that are important for enforcement. Maybe that's, I don't remember we've actually looked at it quite in those terms. Enforcement is not the same as commercial value directly. You know, it's a separate issue. Maybe that's an interesting area, because that is also a little bit more objective than commercial value. The enforcement, what characteristics do you need to be able to enforce your right? That's I'm quite interested in that. I think maybe something we ought to explore further for the future. We've got a long way to go on this, but it's maybe an avenue I think it would be good to look at.
So Peter covered both EDV in the first part of his comments and minimum distance in the second part of his comments. Francesco, I think where Peter ended, or his last comments were directed more toward can the breeder of a similar variety to the new variety under the US test have a more real-time chance to respond versus waiting to the end of the process?
Of course, this is how it works. It's guaranteed under the procedure. The breeder can visit the testing premises, and provided that this is agreed and organized in advance under the supervision of the office, and also opposing parties can do that. So, during an objection. So, indeed, they should be encouraged to do it more. Parties, applicants are always invited to visit the testing station. And when there is an incident in the testing, the examination office informs us. So we even propose them to go and look what is the problem, and also give guidance and inputs and feedback to the examiner in the field to share knowledge and yes.
So, Francesco, remind you breeders that you have an invitation, an open invitation to visit the testing process. Throughout the testing process, of course, you notify the office in advance, and so that they're properly prepared for your visit. But they're glad to have you as part of the process.